Washington, from 1889 to 1989, from state to Pacific Rim power. Our state has thrived in its first 100 years, and so has the Washington State Bar Association. From a total of 456 frontier lawyers admitted to practice between the years of 1854 to 1892, to now more than 15,000 lawyers in 1989. From lawyers who served their clients with pen and ink, by gaslight, traveling by horse and buggy, by train and boat, to lawyers who served clients in virtually every corner of the world with fax machines, telephones, calculators, computers, scanning devices, electronic dictating equipment, photocopiers, and laser printers. Much has changed in the way lawyers deliver legal services to their clients.
This pioneer farmhouse, which today is an office for lawyers, was built in about 1888. On January 19, 1888, 35 members of the Washington Territorial Bar met at the Supreme Court chambers in Olympia, Washington, to form a bar association. They each threw about $5 on the table to get things underway. In 1889, after Washington became a state, the bar changed its name to the Washington State Bar Association. By 1894, there were about 150 members of the association, and the group gathered in Seattle to listen to their president, John Arthur. John Arthur would be the envy of modern presidents because his speech was interrupted by frequent outbursts of applause. Lawyer bashing was already well in vogue. Among other things on that subject, John Arthur said that all lawyers should not be condemned simply because some of their number have, for large fees, countenanced and assisted in organizing gigantic schemes of knavery and plunder. The legal profession is still sound to the core. That was John Arthur. In August 1914, the 26th annual meeting convened in Wenatchee. The association's membership was 675 lawyers, and the chair of the membership committee rose to recommend 18 new lawyers for admission. With this comment about Nelda Yeager, a sole practitioner in Tacoma, quote, "Your committee begs further to report that one of the names to be voted upon this year is that of Miss Nelda Yeager of Tacoma. We are not aware of any reason why members of the opposite sex should not be admitted, and therefore present her name to be voted upon with the rest at the present session." Whereupon President Ira P. Engelhardt of Yakima responded, "Are there any objections? There being none, these proposed members are declared elected." In 1989, we still aspire to such equality in gender, unadorned, undebated. Do you know what they did debate in 1914? Bar dues. They went on at length debating whether bar dues should be $3, $2, or $1 a year. They finally settled on $3, but the following year, in 1915, they reduced the dues to $2. By 1947, the bar dues had climbed to $10. They're a little bit higher than that today. We could not videotape John Arthur or Nelda Yeager or even the entire history of the Washington State Bar Association, but we have recorded a few contemporary reminiscences about that history. There are so very many who do not appear that could have been included. I'm sure we could all think of people. But the beauty of it is they are still among us. Look around you. We are all still here. The Washington State Bar Association.
Actually, it was almost 100 years to the day that the Constitutional Convention was discussing the Article 4 of the state constitution and drafting it, which deals with, of course, courts and the state Supreme Court. As I recall, it was July 26th, something like that, 1889, in Olympia, that the founding fathers, or the framers, were discussing what the state Supreme Court should be, how many justices, etc. But at any rate, they agreed that they should be selected through partisan elections. There should be 5 of them. They discussed for a while that maybe 3 was enough. But they were afraid that if there were 3, maybe 1 justice or judge would dominate the other 2. Or perhaps corporations, businesses, the legislature, but mostly they were worried about corporations might have an influence over one of the justices, and they would be able to dominate the Supreme Court. But they thought 5 was about right. They debated over the pay. They thought that, gee, $3,000 was too much, and it would be a burden on the budget. Others argued that $5,000 because you get what you pay for. And they settled on $4,000 as the annual pay of the justices. As I recall, presently they make $82,700, which will be increased this year. The Bar Association is involved with the state Supreme Court in a kind of symbiotic relationship going both ways in 5 areas. One of them was selection. And I had mentioned that back in 1924-26, to work against Bill Pemberton's candidacy to the state Supreme Court, the Seattle Bar and the State Bar got involved by issuing a poll and buying advertisements in the Times and the PI, working against his candidacy because of their perception of his being a radical and being associated with the left as far as politics was concerned, the Wobblies and so forth. In 1937, they became involved in the appointment process by working out an arrangement with the governor that the governor would not appoint anyone to the state Supreme Court unless that person had been on an approved list of the Bar Association. Now, the State Bar Association became involved in the election process as they had done back in 1924 and 26 in the Bill Pemberton case. They became involved in 1948 when they felt it was necessary to defeat William Millard, who had been on the state Supreme Court since 1928, I think, at least in the late 20s. But the Bar Association took a public poll, that is to say, they polled their own membership and made it public, saying that we support these other individuals and the voters should defeat William Millard and Joseph Mallory. Well, they were successful in defeating William Millard in the general election, but Joseph Mallory succeeded in overcoming the recommendations of the Bar Association. So since 1948, the State Bar Association, often supplemented by the Seattle King County Bar, has made public the results of bar polls to influence the election process.
And would you repeat after me by substituting your name? I, and your name, do solemnly declare I am fully subject to the laws of the state of Washington and the laws of the United States, and will abide by the same.
Before the 1933, there was a state bar association, but it was like the Seattle Bar Association. It was you didn't have to belong, and you could if you wanted to, and so most people did, I guess. But then the Bar Act was passed in '33, and that resulted in the present integrated state bar, where everybody has to belong. Can't practice if you don't belong to the State Bar Association. And anyway, so here was this, not a very elaborate statute, but one that was fairly long, and these wild-eyed guys in the legislature they weren't about to do anything for a bunch of lawyers, you know. And Meekum said that the thing that induced the legislature to pass the statute was that some guy got up on the floor in the House and said, "I don't understand you people." He said, "You're all in favor of labor unions. You all want to close shop. That's all these guys want. Why don't we pass this law?" And according to Meekum, that was the argument that turned the legislature around, which I thought was kind of a funny story.
I will support the Constitution of the State of Washington and the Constitution of the United States.
I was admitted to the bar in August of 1935, and that, of course, was the depths of the Depression. It was shortly after the banks were all closed, and there was very little employment. So that with the people from my graduating class, the boys who had fathers who were lawyers had places to go. Some of them who were going to other communities were able to find employment. But in Seattle, there were few, if any, positions opened. And we went down and rented a small office in the Dexter Horton building and just opened up an office. But it was such a rarity that one of the newspapers heard of it, and they insisted on taking a picture of us walking down the street out in the University District. And the picture was in the paper, and it brought in some business because people thought it was such a novelty. But we were lawyers, and we felt that we were going to be able to do it just as well as anybody else. From the early 50s on up through, I don't know how long, but it was 15 or 18 years, something like that, I served as the chairman of the Board of Bar Examiners, the first woman in the United States to serve in that capacity. And people always show some surprise when they talk about it, but there must be an awful streak of conceit in me, because I've never felt that what I did was anything out of the ordinary. I wasn't a woman lawyer, I was a lawyer. And I think that that's the attitude that women should have, that if they feel they have the ability, they should do what they choose to do. And I think that that has happened now, so that in my own office now, where I practice, we have a great number of lawyers. It's one of the large offices, but we have 19 women lawyers. And often when we take in the new associates, there are more women than men invited to become active lawyers in the office.
1936 was not economically really a good year. I think the top students out of my class went to work at $50 a month. I could not get a job if I wanted to get one. Number one, I was a woman. Number two, nobody wanted to hire anybody. And this was a period of time in which basically some lawyers had closed their offices, and I remember my father talking about it. Had to close their offices and had to go work out of their homes because they couldn't afford to pay rent. So I cashed in the policy of insurance that my mother had bought. I got $100, which was like a fortune. And I rented a typewriter, had some stationery printed, purchased Remington Revised Statutes, $5 down, $5 a month. Brought it all to my father's office, and then one night, about 11 o'clock in the evening, my brother, Carl, who was in law school at the time, put it all in the wheelbarrow. The wheelbarrow had a crooked wheel and made a lot of noise that night, but wheeled the wheelbarrow down to where my office was and set it up. And I started to practice by myself. My office was in a real estate firm. I had taken and painted and refurbished a room. I'd get up at 4 o'clock in the morning to meet my clients from the Seattle Cedar Mill, typing. I typed my own documents. I'd go up, I'm not Catholic, but I go up to St. Alphonsus and say my prayers and ask God to send me clients. He was very good to me. He sent me a lot of clients. It was rough, but it worked. Yeah. I continue practicing because I enjoy helping other people, and I think that I have a very honorable profession, and I think that in my profession I am able to help a person not only to help that individual to understand their rights, to help them get their rights, but also help them to rebuild their life, particularly in my field, which when you go through a divorce, it is the hardest thing. It is the most horrible, excruciating experience that you can have. And it leaves you numb, it leaves you not thinking, it leaves you senseless, and you need guidance. You need guidance not only in the legal process of getting a divorce, but you need guidance so far as your future concern, your future vocation. I enjoy watching that person get well. And as they get well and they come back and there's a smile on their face and a twinkle in their eye, that to me is more compensation than any money, more compensation than winning a lawsuit. Yeah.
I will abide by the rules of professional conduct approved by the Supreme Court of the State of Washington.
Went to the University of Idaho and finished my undergraduate work, then finished my law school at the University of Idaho. And I came over and took the bar in Washington that fall of 1933. Well, in the summertime, the practice of the law was very quiet, and that was the time that the lawyers said, well, get your briefs ready for the fall and get your Supreme Court cases that are set. Try to have them so set that you can prepare your briefs in the summertime, because business is very quiet. We didn't have so many lawyers then, of course. I believe we had about 150 lawyers in the Spokane bar. Now I suppose we have around 1,200. The lawyers were, there was more of a collegial feeling, I think, about the lawyers in the practice because there weren't so many of us. Also, it was the usual thing simply to rely upon another lawyer's giving his word about something that you needn't get your appearance in at such and such a time, or you could extend the period of time for something and it was merely his say-so that you relied upon. I'm sure the times have changed, the conditions have changed, the atmosphere has changed, the relationship perhaps between lawyers has changed, as it's bound to do over a period of time. We have a tremendous number of lawyers that we didn't have before, and it's not impossible, but almost impossible to know the lawyers, and you don't have the occasion to meet them. We do have our bar meetings, but they're not as collegial, I should say, as they used to be, and the relationship isn't the same. I'm sure that comes because primarily of the tremendous number of lawyers.
Before William O. Douglas took the bar, he received an offer to go back, and I believe it was teach either at Columbia University or at Yale, and he decided to leave his home here in central Washington and return to the East. He wrote a book later, Go East, Young Man. Not on that particular subject, but this was involved in it. He did not practice here and was not admitted to the bar here. He went to high school in Yakima, extremely successful in high school, head of the class, went on to Whitman university from which he graduated and which he always befriended, and went on, as you know, to greater heights, head of the Securities and Exchange Commission, the youngest justice ever appointed to the Supreme Court of the United States. He's written more opinions than any other Supreme Court judge we've ever had. And yet, Yakima in central Washington, from where he is a native son, views him with mixed emotions. I don't mean that he was rejected or he was a pariah or anything like that. They're always happy to have him come home, and wished he was more joined in socially more than he did. But they somehow, I guess, felt that he should have been. He was their local boy, went away to college and became great. He should have become, at the minimum, a Republican.
I will maintain the respect due to the courts of justice and judicial officers.
My interest in law practice has come not only through our own firm, but by being active in the Washington State Bar Association section on law office management from 1967 through 1973, and then thereafter through the American Bar Association Economics of Law Practice section. There's been a lot of discussion about how law practice has changed. I can't speak for the centennial, but I can tell you a little bit about how things were in 1948 when I started with an existing 5-lawyer Seattle firm. As far as technology is concerned, we had manual typewriters, carbon paper, no copy machine, a simple telephone system, and a hand-cranked adding machine, and that was about it. There's been some concern expressed that we're losing professionalism as we gain efficiency, but I take the position that the two are not contradictory. Indeed, efficiency is merely part of professionalism. Sometimes professionalism connotes a nostalgic view of the past, of courtesy and decorum, but I think that the efficient delivery of legal services heightens the ability of a person to be professional in the highest and ethical professional standards. The real secret to law practice and the objective is what I call performance competence. That's the ability to translate substantive knowledge into a product that is useful to the client in a timely fashion at a cost that the client can afford. And if we look upon technology as merely a means to the performance of legal services, it perhaps becomes a little bit more meaningful. For example, the yellow pad and the pen of yesteryear were the techniques that we used. We used shorthand dictation and carbon paper, but all those techniques were merely to help us deliver services that would be useful to our clients. Today we have vastly different techniques, but the purpose is still the same.
I will not counsel or maintain any suit or proceeding which shall appear to me to be unjust, or any defense except as I believe to be honestly debatable under the law, unless it is in defense of a person charged with a public offense.
My father was a lawyer, and my uncle was a lawyer. And ever since I was 5 or 6 years old, I wanted to be a criminal defense lawyer as the result of growing up in my dad's household and watching him and my uncle. And I'm one of the few people that ever got to do what they always wanted to do, and I'm not sorry for it. I enjoy my work. It seems to me that the criminal justice system cannot possibly exist in any meaningful fashion without competent criminal lawyers. Our Constitution, in the criminal law sense, rests on 2 or 3 principles. One, a man is entitled to a jury trial. 2, he's presumed to be innocent. 3, the government has the burden of proving him guilty beyond a reasonable doubt. Now, the worst mass murderer in history is still entitled to a jury trial, the presumption of innocence, and the burden is still upon the government to prove him guilty beyond a reasonable doubt. And I think that this comes home to most people, not when they read about so-and-so in the paper being tried and being found guilty, but when somebody that means something to them, their son or their daughter or their next-door neighbor, gets arrested. Now, all of a sudden, those people that are cheering when somebody else is convicted, they are the loudest ones about their rights and their protections, and my God, my little son Johnny couldn't possibly have done this, and we want him protected all the way to the Supreme Court and back, and et cetera, et cetera. Well, little Johnny may very well have done it, but he is entitled to the best possible protection under our system of law. And if we don't have lawyers who are willing to work to that end, the whole system falls apart. The system cannot exist without good criminal defense lawyers, any more than it can exist without good prosecutors or good judges.
There has been a long tradition in the state of Washington with respect to criminal law to uphold the rights of the criminally accused. Long before we started a public defender system, which was only about 20 years ago in 1969, almost all of the attorneys in the state of Washington fully recognized a responsibility to provide legal assistance to people who were accused of criminal wrongdoing. When you were appointed in those days prior to 1969, lawyers took the most significant and serious cases in federal court without being paid a nickel, and in state court being paid a totality of something like $25 for the entirety of a case. In fact, if they even had the gall or the gumption to go to trial, they might get the magnificent sum of another $15 for each day in court. Now, things have changed dramatically, and the rights of the accused are upheld even more specifically than they used to be. But there's been a long tradition, as I say, by which criminal defense lawyers have recognized a responsibility. The most important change, as I see it, is now a poor person who is without funds to hire a lawyer of his own choosing is entitled to have a qualified lawyer and to have that lawyer from the outset of the case. Prior to the public defender system, while lawyers were appointed, they were never appointed until a stage in the proceedings, after which it might have been too late to do as much good for the accused as presently is the case. We also now have a system by which lawyers in the various public defender offices are paid at least a reasonable salary, and the representation extends itself to mental health proceedings, to juvenile proceedings, to lower court proceedings, as well as felony situations. The bottom line is that today in the state of Washington, any human being accused of any kind of crime, be it misdemeanor or felony, be it any crime where you can even serve 5 minutes in jail, regardless of financial considerations, is entitled to have quality counsel to represent him at every step of the way.
I will employ for the purpose of maintaining the causes confided to me only those means consistent with truth and honor. I will never seek to mislead the judge or jury by any artifice or false statement.
The House Un-American Activities Committee first came to Seattle somewhere in the early 50s, and there were only 5 or 6 lawyers out of the entire city who would or could represent people before that committee. And that was in the early days of television, and there were thousands, literally hundreds of thousands of people who watched. And it was so bad that the next time that they came back, our Seattle King County Bar Association said that each officer and each member of the Board of Trustees had a duty to represent people called before that committee. Mike Kopis was now deceased. Mike Kopis was the president of the Bar Association. David J. Williams, now deceased, represented some of the people. So did John Roop, who's now alive. Mr. Sweppy did. David Hamlin did. I did, and perhaps 5 or 6 others. And here we had all of the officers of the Bar Association who volunteered, although directed, and went down and represented those people. And I think that it did a considerable amount to stop the hysteria of those particular times. It's the only place it's ever been done, and it was done here in the city of Seattle by members of the Washington State Bar Association. I could go on endless other cases of somehow a spirit, I'm not sure what it is, a spirit of counsel in this city. And I'm going to be emotional because my best friends are these counsel, are the cases where I have had them on the other side, or other people. And there's been a dignity and an integrity and a courage here that is of great significance. It's been my life, and it's been a great joy. Okay.
I will maintain the confidence and preserve inviolate the secrets of my client, and will accept no compensation in connection with the business of my client, unless this compensation is from or with the knowledge and approval of the client, or with the approval of the court.
Well, I graduated from Gonzaga University in 1951, so this is my 38th year of practice before the bar. I was asked what it was like when I began. I was the second black lawyer in Spokane County, the first having practiced here in 1891. For the first 25 years of my practice, I was the only black lawyer east of the mountains, that is outside Tacoma and Seattle, and between Spokane and Minneapolis. So I instantly got thrown into combat. I think I tried my first-degree murder trial, and then the capital punishment was in existence within 6 months of beginning my practice. The first case that I tried of great public moment should be an encouragement to any black that wants to get into the law business. I walked down the street some 2 months after I had graduated and saw a black man washing windows, and I knew he was a cadet teacher and had been voted the outstanding student teacher of his class. And I said, "Why aren't you in the public school system here in Spokane?" He said, "They won't hire me because I'm black." I filed a lawsuit against the school system that afternoon and opened the door for him. He later became the president of the WEA. And several years later, Muhammad Ali, as a national figure, as you know, was barred from fighting. Upon his return, he had a fight for the world, working towards fighting for the World Championship. The Spokane City Council would not allow him to be shown at the Coliseum. And I brought an action against the Spokane City Council and opened the door for Ali, representing Top-Ranked Boxing Association at the time. So there are steps you can take that'll aid yourself. In the summer of '64, when Cheney, Swarner, and Goodwin was killed, I was in the state of Mississippi working on the civil rights movement. I saw the blood on Medgar Evers' stairs and helped aid and comfort his wife. I know that you can contribute to the society. This last year, my son and I were both delegates to the Democratic National Convention. We were the only father-son national delegate team in the United States, working for Jesse Jackson. There's hope abound in America if you'll get out and pay the price for it. I don't buy this Republican tittle-tattle that we're in a kinder, gentler society. As a matter of fact, it's meaner, more abrasive than it was when I was a kid. But you have to learn and get prepared so that you can protect yourself, your family, your friends, and aid in changing the country. Then it will become, perhaps, a more gentler environment and nation.
I will abstain from all offensive personalities and advance no fact prejudicial to the honor or reputation of a party or witness, unless required by the justice of the cause with which I'm charged.
As far as I know, the early legal aid efforts, at least the recorded legal aid efforts, started in Seattle around 1939, and I discovered a ledger one time which indicates that there was an organization in, I think, April of 1939. At that time, legal aid was more like charity, and it was not the way that it is today. People received a lot of advice, and they were thought to be deserving of legal counseling. They were, that decision was probably made by the lawyer. In 1964, a lot of that changed. Federal funding became available through the War on Poverty, and a different concept was introduced in terms of the provision of legal services to poor people. Primarily, it was that poor people are entitled to access to justice. That was a much different concept than what was presented earlier. We solve a lot of our problems in our society by passing laws, but these laws weren't being enforced as far as poor people were concerned. And I know when I was the head of Evergreen, many times I thought of myself as the chief civil law enforcement officer in the state, because we had laws on the books, and we were in court, we were before administrative agencies, we were down in the legislature, actually representing people as lawyers do, rather than taking a charitable approach to the problem.
The bar has always been very involved in the delivery of legal services. The Washington State Bar was involved, for example, in the founding of Evergreen Legal Services in 1976. The State Bar has historically been very supportive of the concept of equal access to justice and legal services for the poor. Historically, when in the 1970s, the federal government began to play an increasingly larger role in the funding of legal services programs, the activity level of the bar in some communities ebbed. In the 80s, as the federal funding levels for legal services for the poor have waned, the bar has really risen in community after community to the increased level of need. Certainly in the past decade, the numbers of poor people in Washington State have grown dramatically, and the capacity and capability of staff legal services to address the increasing needs of the poor has been diminishing. Consequently, I would describe the 80s as a phase where there has been the most active level of partnership between legal services programs and local and state bar leaders and members of various bar associations throughout the state. Some of this has been encouraged to a tremendous degree by the advent of the Legal Foundation of Washington, which receives interest on lawyers' trust accounts funding and distributes those funds to the 3 federally funded legal services programs in Washington State, as well as to many, many pro bono referral and other entities which also deliver legal services to the poor. What is happening now is that legal services programs, together with pro bono entities and local bar associations, are finding their way to the strongest, most complementary working relationship in this partnership. And I think that is a trend that will continue into the 90s.
I will never reject from any consideration personal to myself the cause of the defenseless or oppressed, or delay unjustly the cause of any person.
We are grateful in the Washington State Bar Association that more and more opportunities for lawyers to become judges is apparent. It has not always been so. Interestingly enough, the first ethnic minority person to become a judge in the state of Washington was in 1965. That was a municipal court judge in the city of Seattle. It happened to have been me. The first minority person, or particularly a black person, to become a Superior Court judge was in 1966 in King County. It happened to have been me. Since that time, of course, things have changed. We now have, in 1989, a handful of ethnic minorities who serve as judges at different levels, all of them in King County as opposed to other counties in the state. We have one Asian in the Seattle Municipal Court, 3 Asians in the King County Superior Court. We have one Latina in the King County Superior Court, and we have 5 blacks or African Americans in the King County Superior Court. Then there is one black or Afro-American in the Supreme Court, and that happens to be me. It is a historical coincidence that I have been the first in these opportunities. I look at it, however, as being the opening of a trend towards opportunities for ethnic minorities in the judiciary. It would be my hope that before too many years have passed, that we will lose track of the number of persons who serve at different judicial levels who are ethnic minorities. It would be my hope, of course, that we would have increased opportunities for women, which is to me just as significant as opportunities for ethnic minorities. There are ethnic minority women lawyers who are competent to be judges. There are ethnic minorities who are male persons who are competent to be judges. What we have to do in the profession, of course, is to encourage, recruit, stimulate, and make it possible for persons to aspire to the judiciary. Otherwise, we will probably, another generation from now, be about where we are now, with underrepresentation of ethnic minorities in the judiciary at all levels.
I think that in the future, if it's got to happen, that more minorities and more women are appointed and elected to the bench. I would predict that in the near future, an Asian member should be or will be appointed or elected to the court. I think another woman, if not 2 or 3 others, ought to be elected. This is an important thing. Symbolically, the state Supreme Court ought to be representative. This says nothing about competency or anything like that. All of the members of the present court are competent, they have different perspectives, so forth. It's an exciting institution as a result of that. But it should be more representative, and I feel it will be.
You hear a lot about some offices being too much a money-making business, but I think that basically most of the lawyers who are members of the Washington State Bar and the Seattle-King County Bar and the Yakima Bar and the Spokane Bar and all across the state are people that feel that they have dedicated themselves to making our community a better community and the lot of all people in the community better.
Despite those numberless changes in the delivery of legal services, there is much in common between those who practiced law then and those who do so today and those who will do so in the future. It is a recognition that the practice of law is imbued with a spirit of public service, that the role of law and of lawyers is to give order to society and all of its relationships, that truth and honor are the hallmarks of this profession, that the principles which each lawyer swears to observe and uphold upon admission to the bar have endured for more than 100 years.